Yes,
Hello.
yes, you're audible.
কি
You're
শুনিছে?
audible, sir.
ঠিক আছে ঠিক আছে।
My lord, I would request to list a matter which is not been listed as there's urgency in the matter.
Today? What urgency is there?
My lord, I filed an application for appointment under compassionate ground. In the meanwhile, I become overage because of non-consideration. And even this 2023 will lapse, I'll be more overage. That's why that's your urgency, my lord.
Okay.
Thank you, my lord.
Lordship, I'd like to mention item 11 to 14. These are analogous matter.
11 to 14.
Yes.
Yes.
I've taken the consent of the opposite party.
Ah.
So, Lordship, can you grant 3 weeks time to file my counter?
2 weeks.
3 weeks.
3 weeks.
Yes.
Vice Secretary, Learned Additional Advocate General, with consent from the other side, Vice will listening the matter after 3 weeks so as to enable her to file counter affidavit. Fair is accordingly allowed.
Lordship.
Please, Your Lordship.
Yes.
Your Lordship, the WBC number 266 of 2023 is to be listed along with the item number 25 to the Lordship, the WBC number 234 of 2023. Your Lordship, this matter has to be heard together because 234 has challenged the step taken by the state respondents. Then after the petition was filed, another fresh step was taken by the state respondents, for which the WPC 266 of 2023 has also been filed. Since it has to be heard together, Lordship, if my Lord may kindly direct the registry to take the file of WPC number 266 along with item number 25.
266 is not listed today.
Yes, Lordship, that is why it has to be heard together, Lordship.
Heard together, but this is listed in the order column today. It is not ready for hearing.
No, no, Lordship.
Ah.
When I say it has to be heard together, Lordship,
Yes.
it has to be taken together because interim stay is required, Lordship. Without interim, the petition is about to become infractious.
Which WPC number?
266 of 2023,
266 of 2023.
my Lord.
Mr. J. Seki, learned counsel for the petitioner,
My Lord.
submits that another WPC being 266 2023 is required to be heard along with the present petition, and therefore contended to issue direct to the registry to list this matter along with WPC number 266 of 2023. Pair of Mr. Seki is accordingly allowed.
Hmm.
Registry shall do the need and list the matter before the court.
My Lord.
May I please, your lordship?
Yes.
I beg to mention item number 26 to 30, lordship,
Yes.
part 2. However, I am implemented only in item number 28, WPC 58 of 2017.
Hmm.
Lordship, this matter is fixed for hearing today, but I have some unavoidable circumstances, difficulties.
Hmm.
So let the matter be fixed in the first week of February, lordship.
First week of February. Yes, madam.
We have no objection, your lordship.
No objection. Your good name, please.
Apila Sanctum, lordship.
Miss Apila Sanctum, learned.
Counsel for respondent number 6 in WPC 58 of 2017.
Learned counsel for the respondent number 6.
6, lordship.
Respondent number 6 in WBC number 58 of 2017.
Lordship.
Page 4. Listing the matter in the first week of
February,
February.
lordship.
Why? Why? What is the ground?
Lordship, some personal difficulties, lordship.
That she has some personal difficulty to argue the matter today. Argue the matters today. Pair of Miss Sanctum is accordingly allowed, being not objected by the learned counsel for the petitioner. Okay.
Your lordship, we have interim.
Till then, interim order shall continue. In interim order in which matter? All the matters?
All the matters.
All the
All the
matters. Interim order shall continue. Yes.
Obliged, lordship.
Please, your lordship,
Yes.
I beg to mention admission item number 17. I still need some more time, your lordship, to file the reply to the counter affidavit filed by the respondent. So if it may be come up after vacation, your lordship.
Your good name?
Aratzla Kips.
Ms. So learned counsel for the petitioner with consent from the other side, price for listening the matter after vacation.
Your lordship.
After vacation. Here is accordingly allowed.
Obliged, ma'am.
May I please, your lordship?
Yes.
May I be pleased to mention item number 20.
Yes.
Your lordship, I have sent the affidavit for vetting and it's going to reach today, your lordship. So I'll be filing my affidavit only on Monday.
Monday.
So after a week, your lordship,
You are
for the state, your lordship.
for the state. Your good name?
Livika, your lordship.
Ms. Levika, learned counsel for the respondents, state respondents. Submits that she has received a para-wise comment.
No, your lordship, I've already sent for vetting.
Acha, she has received the affidavit in opposition.
Yes, your lordship.
Affidavit
Signature,
in
yeah.
opposition, and she will be filing it by Monday.
Yes.
And therefore, praise for listing the matter on
Week,
after a week.
yes, your
After a
lordship.
week. Here is accordingly allowed. Miss, your good name?
I've taken,
Amy. Mr. So learned counsel for the petitioner present and not objected to the prayer made by Ms. So
much
Okay.
obliged.
May I please, your lordship? Lordship, I would like to mention item number 19 on behalf of the counsel for the petitioner Toshi Olongkamo. Item number 19
You inform the other side?
from the petitioner.
No, you inform the other side?
The other side.
Yes, respondent side. Yes, madam. Any objection? Mr. So learned counsel appearing on behalf of Mr. Toshi O. Lamkumar, learned counsel for the petitioner, praise for listening the matter after
after 2 weeks.
After 2 weeks, there is accordingly allowed. Okay.
Lordship, there is interim pass
Interim.
earlier.
Till then, interim order shall continue. Yes.
Please, your Lordship.
May I please, your Lordship? Lordship, I beg to mention item 23. Lordship.
3.
Item 23. Lordship. On behalf of my colleague Kian Gamin, Lordship. Lordship, if this matter can come up after vacation, Lordship. And for the state respondent.
Mr. So learned counsel appearing on behalf of Mr. K. Angam.
Kian Gamin,
Learned state counsel, state learned senior government advocate.
Lordship.
You inform the other side. Who is for the petitioner?
Lordship.
Lordship.
You are for the petitioner
Yes, my lord.
with consent from the other side. Press for listening the matter after a
After vacation.
after vacation. Okay, they are allowed.
Bless you, lordship.
Your Lordship,
Yes.
I'd like to mention item number 18 on behalf of Inauli, government advocate.
Your good name?
Yes, Mosam Longtimer. She has filed the counter pleadings. And if the matter can be listed for next week. Consent has been
Mr.
taken.
So learned counsel appearing on behalf of
Inauli,
Inaoli. Learned counsel for the
respondents 1, 2, and 3.
respondent number 1, 2, and 3. Press for listening the matter after
Next week, Your Lordship.
in the next week.
Yes.
Prayer is accordingly allowed. Who is for the petitioner?
They're not here, but I've taken your consent, Your Lordship.
You have taken
Yes.
consent with consent from the other side. Okay.
Your Lordship, I'd also like to mention item 22 on behalf of Inauli.
Same
Yeah.
order.
Yes, we are yet to receive instructions.
Okay.
Yes,
Same order.
22.
Okay.
So Lordship, Your Lordship, I beg to mention item number 32. Kindly the matter may be fixed on 5th, 12th, 2023, since my senior is in this post.
5th.
5th, 12th, 2023.
Who is your senior?
Wati Jamir,
Your good name?
Alitos,
Ms. Alitose, learned counsel appearing on behalf of Mr. Watizami. Learned counsel for the petitioner submits that Mr. Watizami, learned counsel for the petitioner is indisposed of and therefore pays for listening the matter on 5/12/2023. Prayer is allowed. You are for the respondent,
Lordship, I'm for respondent 7.
respondent number 7. Ms. So-and-so, learned counsel for the respondent number 7, present.
Please, your lordship.
Yes.
My lord, I seek your lordship's indulgence in item number 23. The
Yes.
interim has to be continued, my lord.
Okay. 23 interim shall
Yes, my
continue.
lord. Bless you, lordship.
For motion pertaining to the principal seat through remote video, item number 1.
Yes, Mr. Biswas.
My lord, this is the second application, my lord. My lord, there are certain facts which were not placed before your lordship when the first bail application was moved, my lord. I just want to indicate the facts which will probably show the innocence of the present petitioner who is working as a forester in a division which is not at all connected with the division where the alleged offense had taken place, my lord. My lord, would kindly come to page number 13, 1-3.
Yes, so 1-3 is a identity card.
Absolutely, my lord. My lord will see where he works. He works in Dibrugarh division.
Yes.
Now, my lord will come to the FIR. The allegation is in Tinisukia division. So he has no nexus or he has no role in Tinsukia division. Now I will demonstrate before your lordship why he has been implicated in this case, my lord.
No, no, Mr. Biswas, the occurrence took place not only in Tinsukia but also in Dibrugarh district.
No, my lord, because as far the report of the concerned department goes, it shows that it is in the Tinsukia division, my lord. It is not in the
We
Dibrugarh division.
we are not concerned with the report of the department. We are concerned with the FIR.
My lord, FIR, it is Dibru Saikhwa National Park. It is in Tinsukia.
Maybe, but it continued till Dibrugarh.
My lord, as per the official document, this is one aspect, my lord, that
Not
he
official document, you go to the FIR.
Yes, my lord. FIR, this is to inform you that on the basis of paper cutting of a news item published in Kohima Pratidin, dated 4/3/2023, a preliminary inquiry was conducted by Amrit Chandra Kalita, APS, page number 14, I'm reading, my lord. APS, Deputy Superintendent of Police, Assam, Gauhati, White, such and such. And as per the enquiry report of the enquiry officer, it is stated that during his discreet enquiry, he found the below noted person of Tinsukia and Dibrugarh district, my lord, are engaged in cutting of timbers illegally from Dibru Saikhwa National Park. Now, this Dibru Saikhwa National Park is in Tinsukia, my lord. People may be from any part of the Assam, my lord, but the offense is of, and he is a government officer, my lord. So he cannot be connected. He is not
maybe the entire allegation is against the government, some of the government officers.
Now, my lord, that is precisely, there are certain facts which are not placed before your lordship, which I want to place.
What are the facts?
My lord will come to page number 23. My lord will see, these are all offenses in Dibrugarh Forest Range, where my client, that is the petitioner before your lordship, was the IO of such offenses. In page 23, my lord will see the second last line, Prashanto Hajarika as investigating officer to investigate the offense. Page number 23. Similarly, page number 24. He has been the investigating officer in most of the cases in Dibrugarh division, and he has played a pivotal role to nab the culprits. Now, some person might harbor some enmity against him because he was instrumental in curbing the menace of timber smuggling in Dibrugarh. They might have taken his name, my lord. Now, my lord, your lordship is aware, my lord, can a statement of a co-accused be used against a person without there being any credible?
Yes, it can be during the stage of investigation.
Now, my lord, what is the offense alleged here?
No,
379?
Mr. Biswas, you see, second anticipatory bail application is maintainable only when there is change of circumstances.
My lord, the change
what
change
of circumstances are there in your favor?
My lord, outrightly, my lord, on the personal ground, my lord will kindly come to page number 61, my lord. Page number 61, my lord, his son's marriage is on 18th of December, my lord. And he admittedly, page number 61, and he admittedly, my lord, is cooperating with the investigation. He is not fleeing away from the jurisdiction, my lord. What even on, my lord, I have instruction that he is again called on 4th of December by the IO. He is willing to go on 4th of December. He is willing to visit every weekend, my lord, because he also wants that the real culprit, my lord, he has also served the department for so long, my lord. Some person giving some statement and to deprive him, my lord, of his liberty, right and liberty, my lord, and he's a government servant. If he's taken to custody, 48 hours deemed suspension, his entire family will be ruined, my lord.
Yes, madam.
Lordship, as per the earlier order dated Lordship 18/10/2023, Lordship, Lordship already perused the case diary, Lordship, and as per the order, Lordship, Mr. M. Bhattacharya submit that applicant has received the commission regularly from the co-accused person and his custodial interrogation is necessary, Lordship.
My lord, this is just a statement of some
timber. No, Mr. Biswas, let her complete.
My lord.
Lordship, He was, Lordship, taking the commission, Lordship, regularly from the co-accused Lordship. So his custodial integration was necessary. Lordship.
Yes,
My lord, suppose an officer in charge of a police station, he naps some criminals, my lord. Now some criminal tomorrow say that the officer in charge of a certain police station has taken commission from me. Will it be a ground to arrest the officer in charge of a police station who is arresting people at the altar of his life, my lord? My lord will kindly appreciate.
Mr. Biswas, the court has perused the case diary. There are sufficient materials in the case diary against you.
My lord, I am not contradicting what your lordship has observed. My only point is, if your lordship gives a second thought to the fact that these statements are not of statement of any person of repute. These statements are of co-accused. Co-accused are people who are involved in this timber against whom he has acted in the adjacent district, my lord, in Dibrugarh. He has heavily acted. I have annexed all the reports where he was the investigating officer. They are victimizing him because of him, they could not be successful.
Mr. Biswas, before registration of the FIR, the concerned police officer had visited the place of occurrence.
My lord.
And only thereafter he lodged the FIR and the same was registered with the BIO.
My lord. Now, my lord, in the FIR, my lord.
Okay, Mr. Biswas, at this stage we will call for the case diary.
My lord, my last submission, my lord, before parting, my lord, only one liner, my lord. My lord will kindly see what is the section imputed against the petitioner. It is 379, 411, and 35 and 41 of the Assam Forest Regulation Act. Now, my lord, whatever I understand, my lord, if there is a specific law and a general law, if a specific law is pitted against a general law, it is the special law which will prevail over the general law. 379 and 411
will be considered at the stage of trial, not at this stage.
My lord, prima facie.
M. Biswas, learned counsel for the applicant, and also heard Ms. Endas, learned additional PP for the state respondent. Apprehending arrest in connection with BIO PS case number 21 of 2023 under section 120B, 379, 411, 119 of the IPC, read with section 35 and 41 of the Assam Forest Regulation. This application under section 438 services prepared by applicant, namely Prakanto Hazarika, for grant of periods fail. But having heard the submission of learned advocates of both sides, perusal of the case diary is found to be necessary, and accordingly it is provided that the learned additional PP shall produce the case diary before the court on when,
8th of December, Lordship.
8th of December, okay.
My lord, can it be after the after 18th of December, after the date of his son's marriage, and till then can he be at his home peacefully, my lord, assisting his family member for his son's marriage, his sole son, my lord? Let it come after 18, my lord. Folded hand, I am praying, my lord. At least let him perform his son's marriage, my lord. He has served the government for so long, my lord. He is at the verge of retirement, my lord.
Sir, sir, we have only called for the case diary.
For motion, item 1.
Before I place my case, Lordship, I would like to make an abnormal request. The calendar which is placed before Lordship is obstructing our video.
Okay.
So if it is placed, it will displace if the board officer is requested, little bit on the right hand side, if there is no obstruction for your Lordship.
Yes.
My lord, the present matter is pertaining to selection and election of the village development board member of Yemkham village. The selection and election of the members of the VDB is done in terms of Rule 4, Clause P of the Nagaland VDB model rules. Now, as per the relevant rule, it has to be on by virtue of age, customs, and traditions. on 22nd of August, September 2023, the village council has announced for holding the VDV selection and election to be held on 28th of September 2023. However, in respect of two clans, there were altogether 7 clans. In respect of two clans, there were disputing parties. There were 2 candidates each, 2 parties. Respondent number 5 and 6 and the petitioner number 1 and 2. They are from 2 different clans, that is Izan clan and Ngoli clan. Now, since on 28th, the village council chairman could not take a decision, he has instructed both the parties, the 2 clans, to select and submit the report, and that was to be done on 3rd of October 2023. Accordingly, the respective clan, that is 2 clan, that is Ngoli clan and the Izan clan, we have conducted selection, and as per the majority vote, they have recommended petitioner number 1 and 2. However, the village council chairman, ignoring the majority decision, the 2 persons, that is respondent number 5 and 6, who got less number of votes and support, has been recommended to the deputy commissioner for appointment. And on 8th of November 2023,
Who has recommended?
the village council chairman,
Chairman.
it is called in short VCC, village council chairman. So he has recommended 2 persons, that is respondent number 5 and 6, who got minority support. So the democratic principles of holding the election has been defeated, and the DC has acted upon the recommendation of the village council chairman. So in the process, the democratic principles has been totally ignored, and the action of the village council chairman is absolutely arbitrary. Therefore, this honorable court may
On
intervene.
the recommendation of village council chairman, the deputy commissioner has
Issued
appointed.
appointment order on 8th of November 2023. And my grievance is they let the election be held strictly in accordance with the rules, and in the meantime, the impute order, that is 8 November 2023, may kindly be suspended till the election is held in accordance with law. Because this
Rule means you are referring to Village Development Board model rules,
Yes,
1980.
Lordship. Yes. That is at page 16. Relevant rule is rule 4 clause P. It has to be chosen by the village council, and then by virtue of age or by virtue of traditions and customs. Therefore, the village council chairman has issued notice to the respective clans to nominate, select, and elect their representative to represent the clan. So the clan members held a meeting on 28th, and they have taken the votes. Since there are contending candidates, even from their own clans, there were more than 1 candidate. Therefore, they held the election and selection. And the majority has recommended the petitioner number 1 and 2. Petitioner number 2 is the women representative from Ngoli clan.
Yes, madam.
Notice may be issued at the stage, Lordship.
No, regarding interim peer. Heard Mr. C.T. Zomir, learned senior counsel assisted by Mr.
I am Chin.
I am Chin, learned counsel for the petitioners, and also heard Miss
Yes, done.
learned government advocate for the state respondent. In this petition under Article 226 of the Constitution of India, 2 petitioners, namely Josabemo Izung and Tangsomi T. Noguli, have prayed for causing and setting aside, have put to challenge the order dated 8/11/2023 passed by the Deputy Commissioner
Ukha.
Ukha District and to direct the respondent authorities to appoint the petitioners as VDP member of their respective clans. It is to be noted here that by impugn order dated 8/11/2023, the Deputy Commissioner Ukha have appointed respondent number 5 and 6 as the elected member of Village Development Board,
Yamka village.
Yamka Village. Mr. Zomir, learned counsel for the petitioner, submits that the petitioner number 1 and 2, the petitioner number 1 belongs to which clan?
Isn't clear.
Azum clan,
Yes.
and petitioner number 2 belongs to
Muli clan.
Mauli clan,
Muli.
and they took part in the election for Village Development Board, which was conducted on 28/9/2023 as per the Village Development Board Model Rules 1980. And in the said election, there was a dispute in respect of the petitioner number 1 and private respondent number 5 from Azum clan, and also between petitioner number 2 and respondent number 6 from Jensu Nuguli clan.
Lordship, so far as respondent number 5 and 6 are concerned, respondent number 5 is from Muli clan and respondent number 6 is from Azum clan. Whereas the petitioner number 1 is Azum clan, petitioner number 2 is Muli clan.
Is it correctly mentioned in the synopsis?
Yes. Lordship. Slight variation is there, Lordship.
Yeah.
This is okay, Lordship.
Okay. Okay.
Second paragraph.
And the dispute arose between the respondent number 5 and 6, as they have opposed the candidacy of the petitioners and wanted themselves to be selected as VDP members. Although they did not enjoy the support of majority of their respective clan members. Therefore, the election could not be concluded in respect of the two clans, and the chairman of the village directed the two clans to resolve the dispute and elect a candidate to represent their clan. And the election in respect of these two clans was scheduled on 3/10/2023. Thereafter, the two clans in their separate clan meetings decided to select petitioner number 1 for Azum clan and petitioner number 2 for Jensu Nugli clan. And the said decision was arrived at by a consensus decision by a majority of its clan members, and it was done by duly appending to the signatures of the supporters. Thereafter, on 3/10/2023, as directed by the chairman of the village, the selection was held in respect of these two clans, but the chairman in most arbitrary and illegal manner selected respondent number 5 and 6 instead of the petitioners and recommended their names for appointment, although they did not enjoy the support of the majority. Thereafter, the petitioners have preferred on representation before the Deputy Commissioner Ukha, informing about the illegalities that have been committed by the BDB election in respect of the Yazung clan and Janso Nogli clan. But the Deputy Commissioner did not consider their grievance and proceeded to appoint respondent number 5 and 6 with 5 other persons by impugn order dated 8/11/2023, and being aggrieved, the petitioners approached this court by filing the present petition. Mr. Zomir, learned counsel for the petitioner, further submits that the action of the chairman is arbitrary and illegal and not in conformity with the rule with the Village Development Board Model Rules 1980, and therefore it is contended to allow the petition. On the other hand, Ms. So-and-so, learned counsel for the respondents, submits that at this stage notice may be issued to the respondents. Having heard the submission of learned advocates of both sides, it is provided that notice be issued to the respondents returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. Since no step is not required, you are appearing for all the respondents.
Step in respect of respondent number 4, 5, and 6.
Step will be taken in respect of 5 and 6.
4, 5, and 6.
They are private
Village
respondents,
Council chairman may be represented
yes,
in a different capacity.
not by her.
I don't think can represent respondent number 4.
Okay, notice upon the respondent number 4, 5, and 6 be issued by registered post with AD and also by usual process within a week from today. No formal notice is required to be issued to the respondent number 1, 2, and 3, since Ms. So-and-so, learned government advocate, appeared on behalf of the respondent number 1, 2, and 3. However, extra requisite copy of the petition be furnished to her during the course of the day. Para, having heard the submission of learned advocates of both sides and also considering the documents placed on record, this court is of the prima facie opinion that a case for granting interim stay is made out. Accordingly, it is provided that till returnable date, the impugn order dated 8/11/2023 stands state.
In respect of serial number 3 and 7. Others we are not challenging.
In respect of
Serial number 3 and 7 of the order dated
serial number 3 and
8/11/2023.
7,
Yes,
3 and 7
yes.
till returnable date. List after 4 weeks.
Much obliged.
For motion, item number 2.
May it please your lordship.
Yes.
Lordship, the petitioner herein is seeking for regularization of his service. He was appointed against the resultant vacancy of his mother, who died in harness while in service. And despite being appointed on compassionate ground, the state respondent has failed to consider his case for regularization till date. Therefore, being aggrieved, he has opposed this matter.
Heard Mr.
Yes, Sophie.
S.
Yes, Sophie.
A. Sophie, learned counsel for the petitioner, and also heard Mr. M. Imsen,
Yes.
learned senior government advocate. Yes, what is your submission?
Your lordship, this was happened way back in 2011. Now, yes, I admit, as per the scheme of the compassionate appointment, formulated by the state. It has to be under regular poll. Since 2002 to present 2015 OM, it speaks. So, but now how it was done during that time, that has to be find out. So, Worship notice may be issued so as to find out. I'm representing all the state respondents.
In this petition under Article 226 of the Constitution of India, the petitioner, namely Shri L. Isak Fom, has prayed for issuing direction to the state respondents to regularize his service as lower divisional assistant cum computer assistant under the establishment of subdivisional education officer Longlang, Nagaland. The grievance of the petitioner is that by order dated 16th March 2011, he was appointed as lower divisional assistant within bracket LDA on compassionate ground, as his mother, late I. Samong Fom, who was serving as LDA under the establishment of subdivisional education officer within bracket SDEO Longlang, died in harness on 10/8/2010. The petitioner was appointed on ad hoc basis for a period of 6 months. And since then, he has been serving for last 20 years in the department.
12 years now.
For last 12 years. And his case for regularization was never considered by the state respondents. He had filed one representation to the Principal Director Education, School Education Nagaland, Kohima, for regularization of his service. And the said representation was forwarded by the Assistant District Education Officer Longlang by his letter dated 29 July 2022. But no step has been initiated till date. Being agreed, the petitioner approached this court. Having heard the submission of learned advocates of both sides, it is provided that notice be issued to the respondents, returnable in 4 weeks. Since Mr. M. Imsen, learned senior government advocate, appears and received notice on behalf of all the 4 respondents, no formal notice is required to be issued. However, extra requisite copy of the petition be furnished to him during the course of the day. List the matter after 4 weeks.
For motion, item number 3.
Yes, Lordship.
Yes.
Lordship, the present petitioner here is a work charge mason helper under the establishment of the executive engineer PWT, my lord, in the division of Akanado, that is under the district of the Zinabota Lordship. The petitioner has been serving the department for more than 30 years of yes, Lordship, in the scale of pay, Lordship. So he being eligible for regularization of his service as part of his memorandum 2015, represented to the respondent number 4 for regularization of his service, Your Lordship. However, the representation preferred by the petitioner yielded no result. Therefore, Your Lordship, the petitioner is before this honorable court, bring for regularization of his service as per the office memorandum 2015, Your Lordship.
Yes. You are for the respondent?
Yes, for the state.
What is your view?
Lordship, you notice maybe we should, let me get the proper instructions.
Heard Miss,
Alright, sir, keeps.
learned counsel for the petitioner, and also heard Mr.
Awesome.
Learned government advocate for the state respondent. In this petition under Article 226 of the Constitution of India, the petitioner, namely Sri Khake, has prayed for issuing direction to the respondent authorities to regularize his service in the post of work search within on a work search mission within bracket helper under the establishment of education executive engineer PWD within bracket R&B Agonatu Division, Junegoto, Nagaland. In terms of Office Memorandum dated 17/3/2015. The learned counsel for the petitioner submits that the petitioner was appointed as work search labor by order dated 11/6/1993 under the establishment of Executive Engineer PWD, Agunatu Division, and thereafter he was promoted and granted scale of pay to the post of work search mission certificate helper. And he has rendered service for more than
30 years.
More than 30 years, but his service has not been regularized till date. The learned counsel for the petitioner further submits that the petitioner had filed on representation on 3/10/2023 to the Engineer-in-Chief PWD Nagaland for regularization of his service in terms of the OM dated 17/3/2015, but the same has not been considered by the authorities till date. Whereas Mr. So-and-so learned junior government advocate submits that at this stage notice may be issued, and in the meantime he will obtain necessary instruction from the respondent authorities. Having heard the submission of learned advocates of both sides, it is provided that notice be issued to the respondents returnable in 4 weeks. However, no formal notice is required to be issued since Mr. So-and-so learned government advocate appeared and received notice on behalf of all the respondents. However, extra requisite copy of the petition be furnished to him during the course of the day.
Yes, in the course of the day.
Course of the day or
Course
within-
of the day, Your Lordship.
Course of the day. List up to 4 weeks.
Obliged, my lord.
For motion, item number 4.
May I please, Your Worship?
Yes.
My lord, the petitioner petitions is for non-consideration of the representation that has been submitted to the respondent authorities. And the humble prayer of the petitioner is to give a direction to the respondent authorities to dispose of the representation that has been submitted to the respondent authorities. The facts of the case is that, my lord, the petitioner is presently serving as Sobitar, Cyber and Assam Rifles. And the ACR, apart for 2019 and 20, the respondent number 5 and 6 has given adverse ratings. So the respondent has given a representation to upgrade and to review the ACR and APAR that has been given below benchmark. But those representation has not been disposed of till date. And in the year 2021 and 22 also, the same respondent number 5 and 6 has given the adverse remark. So the petitioner has submitted another representation to dispose of the, with a prayer to upgrade the ratings of the ACR. But till date, the 2 representations which has been submitted by the petitioner has not been disposed of by the respondent authorities. So the only prayer of the petitioner is to give a direction to the respondent authorities to dispose of the representation within a time frame period. And my lord, it is learned that the respondent authorities are contemplating to have a TPC in the month of January. So if the representation is not disposed of, then
Yes.
On behalf of Young Gauhati, learned CGAC, I pray that the matter may be passed over for the day. I'm told he has some difficulties.
my lord, the only prayer is to dispose of the representation.
But
It will not prejudice the respondent authorities.
why the adverse remark has been recorded in his ACR, we do not know. That instruction is required. Let Mr. Varanoti to obtain the instruction in this regard. We will consider your prayer on next day.
My lord, in that case, if this case will be listed on 5th, 5th of December.
Yes. Hard Mr.
M. Gong Jamil.
Learned Counsel for the petitioner and also Hard Mr.
Takakichu on behalf of Young
Takakisu,
Gauhati.
Learned Counsel, appearing on behalf of
Young
Varanoti,
Gauhati.
Learned CGC. Mr. Takakisu submits that Mr. Yaram Goti, Learned CGC, has some medical inconvenience,
Personal difficulties.
personal inconvenience, and therefore could not appear before the court, and therefore the appear is being made to list the matter in the next week. Appear is accordingly allowed. Registry shall list the matter on 5th of December.
Much obliged.
For motion, item number 5.
Lordship, this is the second round of litigation. Lordship, by this petition, I'm challenging the impugned decision of the state respondent by which my indigenous certificate as well as the Shell tribe certificate has been cancelled. Lordship, even in the initial stage, even at one point of time, the state respondent, they have cancelled my indigenous certificate, and for which we have come before this court. Then by writ petition number 194 of 2020, the actions of the state respondent have been set aside. Lordship, may I take a lordship by the present petition? Lordship, by present petition, may I take a lordship to straight away to the decision? Page 27. Page 27 and operative part, lordship, is in page 52, paragraph 26.
Page 50?
Page 52.
Yes.
So, lordship, by this judgment, the two writ petition has been disposed of. This first writ petition 176 of 2019, by which they have come to challenge my appointment order. Then, lordship, by writ petition 194 of 2020, where the state respondent, they have cancelled my indigenous inhabitant certificate. I have challenged it, and by this petition, by this judgment, the decisions of the state respondent have been questioned, set aside. However, while passing the order, this court has directed the state respondent to conduct fresh inquiry, lordship. This is the operative parties in paragraph 26. May I read for all of us, Lordship?
Paragraph?
Paragraph 26, page 52.
Yes.
Paragraph 26.
Yes.
Considering the important issues raised in the present writ petition as to whether the petitioner, that is, the petitioner means the present petitioner also, is an indigenous inhabitant of the state of Nagaland and also a Shil tribe of the state. This court deemed it proper to direct the additional Deputy Commissioner Oguboto to inquire and verify as to whether Serimati Kutoli Sheki, that is the present petitioner, daughter of so-and-so, qualifies the condition to be an indigenous inhabitant of the state of Nagaland as spelled out in the notification number AR 8 August 1976, dated 28/4/1977, issued by the government of Nagaland, Department of PNR, and also as a Shil tribe of the state. In doing so, all reasonable opportunity shall be afforded to the petitioner and all the stakeholders. The additional Deputy Commissioner Poguboto shall also summon and examine the village authorities, elders of Lazami village, Mishilimi village, and Poguboto town to authenticate as to whether Serimati Kutoli Sheki is an indigenous inhabitant of Poguboto, Nagaland. All the statements of the village authorities, elders shall be recorded in writing. The additional Deputy Commissioner Poguboto shall be at liberty to take recourse to all reasonable measures as may be deemed necessary in the conduct of the inquiry. On completion of the exercise, the additional Deputy Commissioner Poguboto shall forward his finding along with all the records of the inquiry to the government of Nagaland, Department of Personal and Administrative Reforms, PNR, Administrative Reform Branch, and or the appropriate authority for a decision in terms of the office memorandum numbers such and such, dated 19/1/1979, and in accordance with law. While taking the decision, the government shall take into consideration the judgment and order dated 13/5/1998, passed by the Honorable Division Bench of the Gauhati High Court in the case of the state of Nagaland versus Ms. M.S. Nilatyo Shukre, reported in 1998 to GLT 112. All such exercises and decisions on the matter shall be completed by the respondent authorities within a period of 6 months from the date of receipt of the copy of this judgment and order. The action taken by the government consequent to the direction passed by the court shall be immediately intimated to the petitioner and all the stakeholders. So, Lordship, pursuant to this judgment, meeting notice, page 64, Lordship. Meeting notice have been circulated by the additional Deputy Commissioner Poguboto, page 64.
Yes.
By which, Lordship, in order to shorten the time, by which the village council chairman, head GB, and the senior GBs of the Mishilimi and Lazami village have been, and also the vice chairman Poguboto and some stakeholders, including the petitioner as well as the respondents in that in the writ petitions, where also has been called for meeting on 12 July 2022 at 11 p.m. at office chamber of the additional Deputy Commissioner Poguboto, Lordship. Responding to it, Lordship, responding to the meeting notice, Lordship, the additional Deputy Commissioner has called a meeting, whereas by which, Lordship, may I take your Lordship to page 77. Page 77. This is a covering letter. By this letter, the meeting minutes has been communicated to the Commissioner Nagaland Kohima. Lordship, the meeting minutes is on in page 78. Page 78. So,
Yes.
Lordship, on 12 July 2022 at 11 a.m., the Deputy Commissioner who has recorded the statements of various leaders and individuals, Lordship.
Yes.
Lordship, then at the bottom, page 79, at the bottom of that meeting minutes, here, may I read, Lordship, at the bottom. Hence, the office of the Additional Deputy Commissioner, Puguwoto, agreed to grant Srimati Kutoli Sheki another 14 days for submissions of any of the documents to the office. So, Lordship, on that very day, since all of them were suddenly called, and even the petitioner who was also present in the case, but after the meeting proceeding has, Lordship, when the meeting proceeding was observed, certain individuals, including the legal counsel who was representing the respondent, was also present in the meeting. So, Lordship, the petitioner who has asked the Additional Deputy Commissioner that in case if they're also to be represented by the legal counsel, then I must also be given the same opportunity. That was the prayer. Then, Lordship, on 27, Lordship. On 27, Lordship, may I take a Lordship to page 65. Objections, which I have submitted to the Additional Deputy Commissioner. May I read, Lordship?
Yes.
To the Additional Deputy Commissioner, Puguwoto, Nagaland. Objections to the inquiry meeting conducted on 12/7/2022 without affording equal opportunity to be heard through representation by a legal counsel. Sir, in reference to the subject cited above, I would like to raise certain objections for your kind perusal and consideration. As per the meeting notice, number such and such dated 2/6/2022, a meeting was called to be held at 11 a.m. at the office chamber of the Additional Deputy Commissioner, Puguwoto. The meeting incorporated invitation only to certain individuals as listed here in below. So these are the leaders and individuals called for the meeting. Lordship, however, it has been witnessed that several individuals were allowed to participate besides the name mentioned in the invitation list. The undersigned is aggrieved by several numbers of individuals from the opposite side being allowed to participate in the said meeting, even though no invitations were officially extended to them. And if the undersigned had the knowledge of such participations which would have been allowed, she would have taken the assistance of more individuals to present her case. However, she had been denied of such opportunity. Besides, the undersigned is enormously aggrieved by the failure to provide equal opportunity for her to be represented by a legal counsel. Although no invitations were extended to the legal representative of both the parties, the legal counsel of the opposite party, who is also representing the case of the opposite party, which is filed before the Honorable Gauhati High Court Kohima bench, was allowed to participate. The opposite party had been allowed to take the assistance of the legal counsel to present her case during the inquiry meeting, and thus denying the undersigned to effectively present her case in a clear violation of the principle of natural justice. Thus, the undersigned raises an objection, though this letter and request for a proper inquiry meeting with invitation of equal representation from both sides and an opportunity to be represented by legal counsel for the undersigned as well, which otherwise is envisaged to prejudice the case of the undersigned. So on the same day, Lordship, on the same day, page 67, another representation has been submitted that the additional deputy commissioner, while proceeding with the inquiry, the case of the state of Nagaland versus Nilatio Shukre has to be taken into consideration, Lordship. On this regard, we have submitted one representation on the same day, Lordship. Lordship, this is a lengthy representation. However, this was submitted on the same day, Lordship. When the petitioner was waiting from the additional deputy commissioner to respond to the representations we have submitted. And also that we were expecting that the statements submitted by various leaders who were present in the inquiry proceeding. In spite of furnishing all those documents and the information, relevant documents, by letter dated 1 August 2022, Lordship, page 77, Lordship. Page 77. The verification of indigenous inhabitant in respect of Sarimati Kutoli Shiki. By this letter dated 1 August 2022. The report, whatever have been received by the additional deputy commissioner, has been communicated and furnished to the commissioner for onward action, Lordship. Lordship, may I read the contents of the letter? Page 77. To the Commissioner, Nagaland Kohima, subject verification of indigenous inhabitant in respect of Sarimati Kutoli Shiki. Sir, with reference to the subject cited above, and in compliance to the directives of the Honorable Gauhati High Court Kohima Bench, case number 176/2019, para 26. I have the honor to submit the sequence of the verification process to authenticate as to whether Sarimati Kutoli Shiki is an indigenous inhabitant of Poguboto, Nagaland. On receipt of the order from the Honorable Gauhati High Court Kohima Bench dated 4th March 2022, a letter was sent to the Village Council Chairman Lazami Mishlimi and Vice Chairman ad hoc Town Committee Poguboto on 26 April 2022 to verify the authenticity of the claims of Sarimati Kutoli Shiki as an indigenous inhabitant of the state of Nagaland and to submit the written report within 1 month from the date of issue of the letter. The written replies were duly received by the office enclosed. Again, on 24th June 2022, a circular was issued to convene a meeting on 12th July 2022, wherein the statement of the members were recorded in the meeting minutes. In the course of the meeting, the contents of the government notification number such and such, dated 28 April 1977, was made clear to all present, and Sarimati Kutoli Shiki was asked to produce any of the documents. As stated in the notification, the respondent requested for more time to produce documents, wherein a time period of another 14 days was granted. Meeting minutes, attendance enclosed. A letter was received from Siri Kutoli Shiki on 27 July 2022, wherein it is stated that the document as prescribed in the government notification number so and so dated 28 April 1977 cannot be produced. Para 8, letter enclosed. This is submitted for your kind information and necessary action, please. So, Lordship, by my representation, 27 July 2022, Lordship. Lordship, this has misquoted and without taking into considerations of my representation. I was not furnished with any of the relevant documents or the statements given by the village leaders. I was not given any opportunity to cross-examine them. And as I have submitted earlier and specifically mentioned in my representation on 27 July 2022, a legal counsel was also allowed to speak and to submit their statements, whereas I was not given that opportunity. So, Lordship, while waiting for the response to respond to my representation, these two representation, Lordship, by impugn notification, page 74. Page 74. This notification has been issued. Lordship, may I read? This is the impugned notification in the present petition, Lordship. I'm impugning this notification.
Yes.
Government of Nagaland, Office of the Additional Deputy Commissioner, Puguboto, Nagaland, dated 25th April 2025. Notification. In pursuance to the Home Department, Home Branch Letter Number so-and-so dated 14th November 2022 and Commissioner Nagaland Letter Number so-and-so dated Kohima 11 April 2023 regarding verification of indigenous inhabitant. Quoted. The matter regarding verification of indigenous inhabitant certificate in respect of Srimati Kutoli Sheki, daughter of late Inaka Sheki, alias such and such, has been examined by AR branch, and it is conveyed that based on the verification report submitted by the Additional Deputy Commissioner Puguboto, and in view of PNR notification number so-and-so dated 28/4/1997, Srimati Kutoli Sheki does not qualify to be indigenous inhabitant of Nagaland, so unquote. Consequently, the indigenous inhabitant certificate registered number 762 dated 14/6/2013 issued for the same hereby stands cancelled. So, Lordship, solely on the basis of the inquiry and the verification report submitted by the Additional Deputy Commissioner Puguboto, this action has been taken. So, Lordship, why before this honorable court, the reasons and on the ground why we are before this honorable court, that inquiry to be conducted. And since earlier also they have cancelled my indigenous certificate as well as the scheduled tribe certificate. Whereas by writ petition by WPC 194 of 2020, Lordship, I have annexed the judgment. By this honorable court has quashed and set aside the decisions and the cancellations the actions of the state respondents, by which my indigenous certificate has been cancelled, Lordship. So, Lordship, now my prayer is limited to in this repetition. The inquiry report that was not done in a fair manner and in total violations of the principle of natural justice, Lordship, in the present case. Now, in the present case, initially, advertisement for appointment to grade 4 post under the establishment of Additional Deputy Commissioner Puguboto was published. We all participated. I was selected after completion of the selection process. Only then one of the petitioners who came to challenge my appointment order, stating that I am not the indigenous inhabitant. I'm not qualified to be appointed against the post. So from there, the statement started, the issue started. And in between, the state respondent, the additional deputy commissioner has even cancelled my indigenous certificate, as well as my Shield Tribe certificate, which we have come before this court to challenge that order. And by order dated 4/3/2022, this court has quashed and set aside the cancellation order of by the state respondent. So, Lordship, thereafter, by this court, order dated 4/3/2022, a fresh inquiry is to be conducted by the additional Deputy Commissioner Poguboto, taking into consideration the case that was decided by the division bench that was not at all taken into consideration. So my limited prayer is that the notification by which my indigenous certificate has been cancelled should be quashed and set aside, and fresh inquiry should be conducted. This is my limited prayer in this writ petition.
Yes, madam.
Pray that notice may be issued at this stage, Lordship.
So in respect of interim pair, do you have any objection?
No motion.
No objection.
No motion.
Heard, Mr.
Tekringi.
Katrenguli, learned counsel for the petitioner, and also heard Miss so learned government advocate for the state respondent. In this petition under Article 226 of the Constitution of India, the petitioner has right for posting the letter number home stroke SCST -02 stroke IIN stroke 2021 090 dated 14/11/2022, which communicate the decision of PNAR department, and number 2, the notification number ADC stroke ESWT -18 stroke 2022 stroke 75 dated 25/4/2023, issued by the additional deputy commissioner Fugaboto, Nagaland, by which the petitioner was disqualified from being indigenous inhabitant or not disqualified of the indigenous inhabitant status, and the inquiry report dated 12/7/22 submitted by additional deputy commissioner Fugaboto, Nagaland. Mr. So-and-so learned counsel for the petitioner submits that the petitioner was appointed in the post of grade 4 in the establishment of additional deputy commissioner Fugaboto through an open advertisement, and thereafter respondent number 7 had filed one petition, filed one writ petition being WPC number 176 within bracket K 2019, challenging the appointment of the petitioner on the basis that she is a landowner on which the establishment of ADC Fugaboto is situated, and also on the ground that the petitioner is not an indigenous inhabitant of Nagaland, and as such, in her place, the respondent number 7 ought to have been appointed. The learned counsel for the petitioner further submits that while the matter was pending before this court, the ADC Fugaboto had cancelled the indigenous inhabitant certificate and scheduled tribes certificate of the petitioner. Thereafter, the petitioner has challenged the same by filing WPC number 194/2020 and by judgment and order dated 4/3/2023, this court was pleased to allow her petition and also pleased to dismiss the WPC number 176 of 2019 filed by the respondent number 7. And further, this court was pleased to direct to whom the direction was issued.
The additional Deputy Commissioner Puguboto.
Direction was issued to the additional Deputy Commissioner Fugaboto to conduct fresh inquiry with regard to the determination of the petitioner's indigenous inhabitant and scheduled tribe status by affording opportunity of being heard to the petitioner and examining and recording statement of the stakeholders. And also by taking into account the judgment and order of this court in the state of Nagaland versus Milatu Sukeri, reported in 1998 2 GLT 102. Thereafter, the respondent number 7 had preferred an appeal challenging the judgment and order dated 4/3/2023. Then what happened to that?
That is still pending.
And the said appeal is still pending. Thereafter, White notice number ADC stroke ESTT-18 stroke 2022 stroke 125 dated 24/6/2022, the ADC Fugaboto Nagaland invited certain individuals to attend the meeting on 12/7/2022 as a part of inquiry process. Then being aggrieved with the manner of conducting the inquiry, where the petitioner was not afforded sufficient opportunity to present her case, and where she has filed one objection letter dated 27/7/2022 and a representation of the same date on the same date seeking for fair conduct of inquiry, but she has not received any response from the ADC Fugaboto, and thereby the learned ADC has violated the principle of natural justice and conducted the inquiry in arbitrary manner, and ultimately notification number ADC ESTT ADC stroke ESTT 28 stroke 2022 stroke 75 dated 25/4/2023 was passed, whereby it has been held that the petitioner does not qualify to be an indigenous inhabitant of Nagaland. The learned counsel for the petitioner further submits that the inquiry was conducted in an arbitrary manner and without affording opportunity to the petitioner to produce her documents, and therefore it is contended to set aside the aforesaid notification dated 25/4/2023. Having heard the submission of learned advocates of both sides. Now, on the other hand, Ms. So-and-so learned counsel for the state respondents submits that and this says notice may be issued to the respondents. Having heard the submission of learned advocates of both sides, it is provided that Notice be issued to the respondents returnable in 4 weeks. Step upon respondent number 7 be taken by registered post with AD and also by usual process within a week from today. No formal notice is required to be issued to the respondent number 1, 2, 3, 4, 5, and 6. Since Ms. So-and-so learned government advocate appears and received notice on behalf of all aforesaid respondents. However, extra requisite copy of the petition be furnished to them, furnished to her during the course of the day. Para, having considered the submission of learned counsel for the petitioner, learned counsel for both the parties and also considering the facts and circumstances on the record, this court is of the prima facie opinion that a case for granting interim stay of the notification dated, impugned notification dated 25/4/2023 is made out. And accordingly, it is provided that the impugned notification number EDC/ESTT -18/2022/75 dated 25/4/2023 stands state till returnable date. List of performance.
Much obliged.
May I please, your lordship? My
Yes.
apology for the inconvenience. I may be allowed to make one correction, lordship. During the mention hour, I have mentioned adjournment for item number 26 to 29, which is an analogous matter. But inadvertently, I have mentioned for item number 30 also, lordship, which is not my matter. So the adjourned matter should be read from item number 26 to
Okay.
29,
Okay.
lordship. Oblige, lordship.
For motion, item number 6.
Bless your lordship.
Yes.
Lordship, item number 6 and 7, they are analogous, your lordship. But I pray that item number 7, that is WBC 298, may be taken up first, your lordship, since the matter is from the earlier court's order, your lordship. WBC
Item number 7.
Yes, lordship. Your lordship, here the petitioner, your lordship, he is presently serving as a carpentry helper on a top basis, which he was appointed on the basis of land ownership, your lordship, under GMB's school Chitima, your lordship. And then earlier, two writ petition was filed before this court, your lordship, that is WBC 73 of 2018, that was where that particular petitioner challenged my appointment order, your lordship, on the basis of compassionate ground. And then I also filed a writ petition that is WBC 110 before this honorable court. So these two writ petitions were disposed of by this honorable court. The relevant order is at page 59, your lordship, where page 59. Page 59, paragraph 19, your lordship. The Deputy Commissioner Kohima was directed to make a detailed inquiry on the, your lordship, I'll read from the bar 19, your lordship. The Deputy Commissioner Kohima shall accordingly make a detailed inquiry on the ownership of the land where the GME Stadium is located, with the participation of all the stakeholders, including the petitioner, the village authorities, and the clans who have donated the land for the school. On completion of the inquiry, the Deputy Commissioner Kohima shall submit his findings to the Government of Nagaland Department of School Education. This exercise shall be carried out and completed by the Deputy Commissioner Kohima within a period of 90 days from the date of this judgment, your lordship. So after this direction, your lordship, inquiry was conducted by the Deputy Commissioner's Office, your lordship. And then here the petitioner is secret by the inquiry committee report, your lordship, which I enclosed it in annexure 12, page 62, your lordship. And then the petitioner is secret by this Indian committee report, your lordship. The relevant page is annexure 13, page 63, your lordship. Your lordship, I'll just read the last paragraph, your lordship. This is clear, your lordship. Page 63. Considering the above facts and circumstances, it may be reasoned that the ancestral land owner of the plot of land where the present GM's stand is late Sepu Chakroni in his family. That is the present petitioner, your lordship. However, by virtue of donation for the development of community assets and property, the present owner is the community your lordship. Now the inquiry report, the petitioner is agreed by this. Why? Because your lordship, at one end, in the earlier, they are stating that the ancestral land owner of the plot of land belongs to me. And then secondly, they are saying that since it was donated to the community, now it belongs to the community your lordship. But then one thing is that this land transaction was done between the petitioners and the government of Nagaland, that is particularly the school education department your lordship. And then on the basis of that, I was given appointment. But then the village authorities and the clan representatives, they are claiming that the land belongs to the community your lordship. So being aggrieved, the petitioner is before this honorable praying that this particular statement, particular number 2 in 3 your lordship, will be quashed and set aside your lordship. And then it is very clear that the land in question was donated by my late grandfather, your lordship, to the Department of School Education.
Yes.
So for the state, as far as the state is concerned, I would be required to receive proper instructions. In the meantime, notice may be issued to private parties.
Regarding interim pair,
Your lordship may be considered on the next returnable date.
Your lordship,
Because
the
I
next
have
returnable
no
it will be
instructions
it
as
will
such.
come after vacation only. And then if the Indian order is not state, your lordship, it will be between the petitioners and the villagers, your lordship. It will be a big problem, your lordship. And then secondly, the petitioner is presently serving as carpentry helper, your lordship. And then we all know the situation how the school infrastructures are in this villages, your lordship, the school. So carpentry helper is a necessary, so you is a necessary post, your lordship, under the department. So I pray that then order may be granted directing the staying the Indian order, and secondly, directing the state response particular number 2, not the also the petitioner from should be still the pending disposal, your lordship.
heard Mr. Supangwate Waling, learned counsel for the petitioner, and also heard Mr. So-and-so, learned government advocate for the state respondent.
1 to 5, your lordship, state respondents.
1 to 5. In this petition under Article 226 of the Constitution of India, the petitioner has prayed for passing and setting aside.
Your lordship, as far as the interim is concerned, can the matter be listed before the vacation starts? In the meantime, I will try to receive instructions.
Prayed for passing the inquiry, a report of inquiry committee dated 17/6/2023, particularly at serial number 2 and 3 of the said report, and also passing and setting aside the order dated 20th/12/2017, cancelling the land ownership certificate of the petitioner. And also to affirm the land ownership certificate dated 23rd/11/2016, issued by the Deputy Commissioner Kohima, Nagaland. The petitioner is aggrieved by the inquiry committee report dated 17/6/2023, submitted by the SDO within bracket C Sodor of the Office of the Deputy Commissioner Kohima, Nagaland, where the SDO has conducted spot verification, where the committee members has conducted spot verification and arrived at the finding with an inverted comma that the ancestral landowner of the plot of land where the present GMS stands is of late Jubu O Sakarno and his family. However, by virtue of donation for the development of the community assets, struck property, comma, the present owner is the community. Inverted comma close. Stop. The learned counsel for the petitioner submits that the land in question was land in question is belonging to belongs to one late Jubu O Sukarno, and the same transaction was made between his grandfather and the government, particularly for the Department of School Education. And the respondents, particularly the Village Council, Sidima, and the other clan members, taking the stand that the land belongs to the community is totally illegal and against the resolution and commitment made by the village authorities. And therefore, the learned council submits that the impugned office order dated you paid for staying both the order 17/6/2023 and 2017.
Lordship, only 17/6/2023, page 29.
You paid for staying the operation of the inquiry committee report dated 17/6/2023, particularly at serial number 2 and 3 of the findings. Whereas the learned government advocate submits that at this stage notice may be issued and he may be given time to obtain necessary instruction in respect of the interim period and to list the matter before the vacation. But having heard the submission of learned advocates of both sides, it is provided that notice be issued to the respondents returnable in 4 weeks, step upon respondent number 6, 7, 8, and 9.
6 to 16, Your Lordship.
6 to 16 be taken by registered post with AD and also by usual process within a week from today. No formal notice is required to be issued to respondent number 1 to 5 since Mr. So-and-so learned government advocate appears and received notice. However, extra requisite copy of the petition be furnished during the course of the day. List the matter on when suggested that before vacation.
Your Lordship, for that, Your Lordship, I have one submission, Your Lordship. This inquiry report which I've impugned in the writ petition, Your Lordship, it was never furnished to the petitioner till date, Your Lordship. So I'm afraid if urgent interim is not granted, Your Lordship, it may create some burden, Your Lordship. I've clearly stated in my paragraph also, till date, even the deputy commissioner, they have not given the official copy to me, the inquiry report, Your Lordship.
But from where you have received it?
Yes, Lordship.
From where you have received
From outside, Your Lordship, from the department, Your Lordship. And then even in the copy, there is not even a mention copy to the petitioner, Your Lordship. So unless a strict observance is given, Your Lordship, it will.
So we'll fix it on next date, on the next week. In the meantime, he will let him obtain his. We'll fix it date.
Then Your Lordship on
5th of December.
if Your Lordship, I'll be on leave, Your Lordship. So I agree that on 11, Your Lordship.
11.
Your Lordship,
Place the matter on
11 may be a problem for me.
Why?
I'll be out of station. Oh, that's fine.
Then
Your Lordship, 13, Your Lordship.
13. 13 is Wednesday. So there is the division. 14. 14. 14.
Okay.
On that day, the interim pair will be considered. Interim pair of the petitioner will be considered. Say, what is this? Item number 6 then?
Your Lordship, item 6, these are the petitioners are the landowners, Your Lordship. So they are challenging the same impugned inquiry report, Your Lordship.
Okay, you pass the same order. I will correct.
Bless you.
For motion, item number 8.
My lord,
Yes.
my father, Sri Limawati, was appointed as a teacher in 2000. Thereafter, in page number, that is in page number 12, my lord. Thereafter, it was regularized in 2012. The service was regularized in 2012, page number 13. However, my father died while he was service 2017 November 2017 he died in service. As such, leaving my mother and 3 of my other younger siblings. We have 4 children. Having no means to fend our family, I applied for a job under the compassionate scheme on 22/12/2021, page number 17. My lord, page number 17. There I have mentioned about my mother, myself, and my other 2 other younger siblings, praying for a suitable job. By the time I was studying my graduation, I was undergoing my graduation degree. Thereafter, subsequently, my petition was not considered. Thereafter, I submitted another application on 19/10/2022, page number 18. Thereafter, I've submitted on 13/12/2022. Till my lord, my petition, my prayer has not been considered. And in the meantime, my mother and my siblings were made to suffer so much, and finding it difficult to defend ourselves. As such, I prayed before this honorable court to direct the respondent authorities to consider my petition and consider my appointment within a period of time as per the office memorandum of 2015, which I've annexed in my petition, page number 37. Paragraph number 2, page number 7,
No,
number 2.
you have 2 pairs. One is to direct the respondent authority to appoint you.
Yes, my lord.
And the other is to direct the respondent authorities to dispose of your representation.
Yes, my lord.
So which one you are paying? You are pressing?
I'll pray for both, my lord, to consider my appointment as well as to dispose of my petition, my applications.
Yes.
Lordship, I don't have any objection since it's in OM, so I don't have any objection for disposing the representation.
At this stage.
No, in respect of this pair number 1.
Yeah. My lord, it is clear in the OAM and it will not create any prejudice to the respondent.
Let him obtain instruction. Why the respondents could not dispose of the representation?
Yeah, my lord.
On next day.
That's why, since it's been a long time that I filed for 4 applications so far representations, and till now they have not disposed of mine. So my only prayer is limited. My limited prayer is to dispose of my representation.
Only.
Yeah.
The other pair?
To consider my appointment as per my prayer, as per my representation, my lord.
Achha.
It is here in the OAM, and no prejudice is being meted out to the respondents, my lord. My lord, such cases has been disposed of in earlier and motion stage also.
No, that's all right. I have no problem.
Yes.
Okay. Heard, mister?
Hello, Babang Ao.
Learned counsel for the petitioner and also heard Mr.
Jum December.
Learned,
State. Respondent.
learned government advocate for the state respondent. In this petition, under Article 226 of the Constitution of India, the petitioner has tried for issuing number one, issuing direction to the respondent authorities to appoint the petitioner in any grade 3 post on compassionate ground in terms of OM number ER-8/878 dated 17/9/2015, issued by the Government of Nagaland Personnel and Administrative Reform Department, Nagaland. And number two, to direct the respondent authorities to dispose of his representation dated 22/12/2021, Annexure D, 19/10/2022, Annexure E, 13/12/2022, Annexure F, and 18/10/2023, Annexure Z. For appointment on completion and growth. The learned counsel for the petitioner submits that the father of the petitioner was working as a graduate teacher at GPS Ungar Mukoksang district under School Education Department, Nagaland. And he died in harness on 7/11/2017, leaving behind the petitioner, his mother, and his 3 siblings. As the father of the petitioner was the sole breadwinner of the family, and in need of financial assistance, having no regular service holder in the family and other source of income, the petitioner had filed 4 representation on 22/12/21, 19/10/2022, 13/12/2022, and 18/10/2023 to the respondent authorities for appointment on compassionate ground. But till date, the respondent authorities have not considered the same, for which the petitioner and his family members are suffering a lot. The learned counsel for the petitioner further submits that this writ petition may be disposed of at this motion itself by issuing direction to the respondent authorities to dispose of the representation filed by the petitioner on 22/12/21, 19/10/2022, 13/12/2022, and 18/10/2023. The learned government advocate for the state respondent submits that he has no objection in the event of disposing of this writ petition in the motion stage itself, as the pair of the petitioner is based on office memorandum number ER-8/878 dated. What is the date of the notification or memorandum? Dated 17/9/2015. Having heard the submission of learned advocates of both sides, I have carefully gone to the petition and the documents placed on record. It is not in dispute that the father of the petitioner was serving as a teacher, graduate teacher at GPS Ungar Mukoksang district under School Education Department, and that he died in harness on 7/11/2027, leaving behind the petitioner and his mother and 3 siblings. It is also not in dispute that he was the sole breadwinner of the family. And after his demise, the family of the petitioner has been suffering a lot. Having considered above, and also as agreed by learned advocates of both the parties, this court is inclined to dispose of this writ petition in the motion itself by directing the respondent authorities to dispose of the representation dated so and so, so and so, so and so within a period of 1 month from today by a speaking order. The parties have to bear their own cost.
For motion, item number 9.
By this brief petition, I am sealing the order dated 12 September 2023 at page 16. By which the collector, Kohima, had dismissed my reference application by entering the merits of the application itself.
So the land belongs to you.
That is a subject matter of dispute before the district court at the moment. But my reference application, if it is to be referred, then they'll be subject to the outcome of that decision.
Which is
The
case pending before the district court.
Yes.
Yes.
That's maybe issue of it.
Heard Mr. R. Iralo.
L.
Iralo. Learned counsel for the petitioner, and also heard Ms. So-and-so, learned government advocate for the state respondent. This petition under Article 226 of the Constitution of India, the petitioner has put to challenge the order dated 12/9/2023 passed by the Deputy Commissioner Kohima, Nagaland. It is to be noted here that by order dated so and so, the Deputy Commissioner Kohima, Nagaland has dismissed the petition filed by the petitioner under Section 12(1)(a) of the Nagaland Land Requisition and Acquisition Act 1965 for making a reference to the court. Having heard the submission of the learned counsel for the petitioner submits that the ancestral land of the petitioner was acquired by the state without issuing notice and award to the petitioner as mandated under Section 9 and 11 of the Nagaland Land Requisition and Acquisition Act 1965. And while acquiring the land of the petitioner, the compensation was paid to a wrong person. Thereafter, the petitioner approached the Gauhati of Kohima Village Council, but the same failed to yield any result. Thereafter, the petitioner had preferred an appeal before the principal district judge, Dimapur, Kohima, which was registered as civil appeal number 1 of 2022. And an interlocutory application was also filed for a temporary injunction. And the learned principal district judge was pleased to suspend the operation of GB's decision. And the said civil appeal is pending before the learned court below till date. Thereafter, the petitioner has filed an application before the Deputy Commissioner Kohima for reference to the Principal Civil Court under Section 12A, 12(1)A of the Nagaland Land Acquisition and Requisition Act 1965. But by impugn order dated so the learned Deputy Commissioner Kohima has dismissed the petition. Being aggrieved, the petitioner is before this court. But having heard the submission of learned advocates of both sides, it is provided that notice be issued to the respondent, returnable in 4 weeks. However, no formal notice is required to be issued since Ms. So-and-so learned government advocate appears and receive notice on behalf of both the respondents. However, extra requisite copy of the petition be furnished to her during the course of the day. List the matter after 4 weeks.
For motion, item number 10.
The present petitioner being aggrieved by the consideration of his case for appointment as Chowkidar on the basis of land ownership in veterinary outpost, Hongsam, Napokchung, Nagaland. Is approaching this honorable for challenging the improved communication dated 28 August 2023, whereby the administrative approval was accorded for appointment of the private respondent number 6. Here, without considering the case of the petitioner who is the landowner, the private respondent number 6 was appointed by the impugn order dated 13 September 2023, pursuant to the administrative approval dated 28 August 2023, in violation of constitutional and employment policy.
Yes.
Your Lordship, I would need to receive instructions.
Your Lordship may be pleased to pass an order making the appointment of respondent number 6 subject to the outcome of the present petition.
Your Lordship, the private respondent must have already started his work. So it'd be better to give her an opportunity.
Heard Miss Learned Counsel for the petitioner, and also heard Mr. So Learned Government Advocate for the state respondent. In this petition under Article 226 of the Constitution of India, the petitioner Shri Dasimlam Sang has has put to challenge the notification dated 5th March 2018 issued by the Secretary to the Government of Nagaland Land Revenue Department, Kohima. And number 2, communication dated 28 August 2023 issued by the Secretary to the Government of Nagaland, Department of Animal Husbandry and Veterinary, Nagaland, Kohima. And the order dated 13 September 2023 issued by the Director, Animal Husbandry and Veterinary Services, Nagaland, Kohima. And 4, to direct the respondent authority to consider the case of the petitioner for being appointed as Sokidar EAC Assam on land ownership basis. The grievance of the petitioner is that on the basis of land ownership, he has applied for a post of Sokidar in veterinary outpost, Pasang, Mokoksang, Nagaland. But instead of appointing the petitioner, the respondent authorities have appointed respondent number have appointed the private have accorded administrative approval for appointment of the private respondent.
Respondent number 6.
That is respondent number 6, and consequently issued the appointment order dated 13 September 2023. Being agreed, the petitioner has approached this court by filing the payment petition. Having heard the submission of Lord Advocates of both sides, it is provided that notice be issued to the respondents returnable in 4 weeks. Step upon respondent number 6 be taken by registered post and also by usual process within a week from today. No formal notice is required to be issued to the respondent number 1, 2, 3, 4, and 5 since Mr. So Learned Counsel appeared on their behalf and received notice. However, extra requisite copy of the petition will be furnished to them during the course of the day. This is the matter before vacation. Whether 4 weeks will be completed before vacation. No.
Vacation will start after a week.
Interim pair will be considered. Interim pair of the petitioner will be considered on next returnable date. This after 4 weeks.
For motion from the supplementary cost list, item number 33.
Hello. Thank you for allowing me to. My husband was working as a motor vehicle checker, my lord. Then, unfortunately, he died in harness in 2019. Death certificate, I've annexed in page number 13, my lord. That's my husband's death certificate. We have no children out of our marriage. However, I'm an unemployed woman and having no means. I applied for a job and I've written an application to the department on 2018 2020, page number 15, my lord. Pray for submission of application for appointment on compassionate ground. Thereafter, my petition was not considered. As such, again, I submitted another application on 15/6/2020, my lord. Till the time when I applied my petition application, I was 39 years. Thereafter, my petition was not considered. Now I've crossed the age of 40, my lord. The compassionate scheme under 2015 is up to 40 years. However, because of my non-consideration of my petition, I have crossed my age. I've crossed 40 years now. However, I come before this honorable court to direct respondents to consider my application and consider my appointment under the scheme.
Yes, madam.
This stage, madam.
So you want the petition to be disposed of today?
Yes, madam. Thereafter, I will approach the office of the respondents, madam. Thank you.
Heard, Mr.
Alam mo pang ako.
Learned counsel for the petitioner and also heard, Miss. Learned counsel for the state respondent. In this petition under Article 226 of the Constitution of India, the petitioner has right for number one, to direct the respondent authorities to appoint the petitioner in any grade 3 post on compassionate ground in terms of the office memorandum number AR-8/8/78 dated 17/9/2015 issued by the Government of Nagaland, Personnel and Administrative Reform Department, Nagaland, Kohima, and number two, to direct the respondent authorities to dispose of the representation dated 18/5/2020, 15/6/2020, and 16/5/2023, and to consider the case of the petitioner for appointment on compassionate ground. The grievance of the petitioner is that the husband of the petitioner was working as motor vehicle shaker in a regular post under Transport Department, Nagaland, and he died in harness on 23rd 10/2019, leaving behind the petitioner. And he was the sole breadwinner of the family. And she is in need of financial assistance as she has no regular service, as there is no regular service holder in the family, and she has no other source of income. And thereafter, the petitioner on 18/5/2020 and 15/6/2020 and 16/5/2023 submitted representations to the respondent authorities for appointment on compassionate ground, but the same failed to yield any result till date. The learned counsel for the petitioner submits that at the time of death of her husband, the age of the petitioner was 29 years. 39 years. 39 years. And now she has completed 40 years.
Yes, she's in
And
43
as
years.
per the scheme for appointment on compassionate ground, the age of the petitioner should be
Below 40, relax up to 35 years. My lord,
below
40 years.
below 40 years.
Yes, up to 40 years.
Below 40 years. And as such, it is contended that this petition may be disposed of by directing the respondent authorities to consider the representations dated so and so submitted by the petitioner and to appoint her on compassionate ground. The learned counsel for the respondent authority submits that she has no objection in the event of disposing of this petition, that this motion is itself by issuing direction to the respondent authorities to consider and dispose of the petition. Whereas in view of the submission of learned advocates of both sides, and also as agreed upon, this court is inclined to dispose of this petition by directing the respondent authorities to consider and dispose of the representation submitted by the petitioner for being appointed in any grade 3 post on compassionate ground. On compassionate ground. The parties have to bear
My lord,
their own cost.
I will pray for a time period.
Within a period of 1 month, 1
month-
month from today.
3 months or so. 3 months or so.
3 months from today. By a speaking order.
Thank you, my lord.
For admission, item number 15.
Lordship, this case was subject to the outcome of that petition for service rules. Okay? The writ was dismissed. The petitioners were in the process of filing an appeal and presently some developments are going on. The department is considering a committee for reviewing the service rules. So the matter is still under process. So if sometime maybe 2 weeks.
After 2 weeks.
After 2 weeks.
Okay.
After the vacation.
My lord, otherwise, I represent the prior respondent number 5. In fact, this petition become practically infractuous.
In view of the
infractuous in view of the division bench judgment. Yes, because in the same petitioner filed the earlier repetition challenging the rules, and the rules was challenged because rule provides for classification, and on going through the rules and the pleadings, the division bench has come to the conclusion that petition was has no merit, so it was dismissed. So now the same repetition, this repetition was filed when the repetition was the earlier pending. So now since earlier was dismissed, now this is infractuous. I have the judgment. So therefore, anyway, he is my own brother. Otherwise, the petition is more or less infractuous now in view of the division judgment. Because in the earlier division bench judgment, they are challenging the rules, questioning whether the rule was constitutionally valid, particularly violating Articles 14, 16. That was thoroughly discussed, debated, and then finding was given that there was no infirmity of the rules. Now, in this present case, the petitioner asking, challenging my promotion to the post of deputy director for giving the promotion on the stand of the rules. So when the rule is already upheld by the division bench, then there is no case in the present case. So therefore, first, he's asking short time, otherwise it's more or less infractuous, madam.
There is no stay order in this, in the instant case. But since new developments are going on,
Okay. Heard Mr. T. Pangimar, learned counsel for the petitioner, and Mr. Ezo, learned counsel for the respondent number
5,
respondent number 5, and Mr. L. Iralo. You are for?
No, he is assisting me.
Acha.
Mr. Taka, yes.
Acha, sorry. Yes. And madam, learned counsel for the state respondent. The learned counsel for the petitioner submits that some new developments are going on, and as such, the matter may be listed after 2 weeks. After 2 weeks. Mr. Zhou, learned counsel for the respondent number 5, submits that he has no objection. No objection, though, in view of the judgment of the division bench in WPC number
261.
261 of 2021, this repetition practically become
Infractious.
However, considering the prayer being made by the learned counsel for the petitioner, it's provided that justice shall list the matter after 2 weeks.
March of life.
For admission, item number 16.
May I please, Your Lordship?
Yes.
Lordship, on the last occasion, this honorable court has directed the state respondent to take a necessary step to recover the money which was paid to the private respondent number 6, Lordship. And Lordship, particularly Lordship, I would like to place the instruction that I received from the respondent, Lordship. Action has been taken, Lordship, against the respondent number 6.
No, you filed it by way of an affidavit.
Yes. But Lordship, on the last occasion, this honorable court has directed to place the instruction, Lordship. So, Lordship, may kindly come to the portion that is page 2, Lordship. Page 2. Page 2 of the same instruction. Here, both the petitioner as well as the private respondent was summoned by the authority, Lordship. And thereafter, Lordship, even the private respondent has also admitted to the fact that we have received and
So, what order is to be passed today?
Your Lordship, the issue is like this. The state respondents are liable to pay me the compensation. Now, what happened was, without my knowledge,
They paid it to others.
they had paid it to the private respondent. Now, I'm claiming that the state respondents should pay me the money. If any recovery is to be done, it is for them to recover it, because they had wrongfully and illegally paid out the money which is due to me. Now, this matter has been pending for quite some time, Your Lordship, and on one occasion, a direction was given for payment of some cost also, and that cost also is to go into the purse of the.
that I have taken, Lordship.
It is not alleviating my suffering. So, if the matter may be disposed of with a direction that the state respondents clear the dues within a certain period of time, and then if they want, they can recover it from the private respondent. It's as simple as that. I have no hand in the illegal payment to the private respondent.
That's all right, but if they fail to recover it from the private respondent, what would?
Yes,
Your Lordship, in that case, it is their responsibility only, Your Lordship. Because in the first place, without my knowledge at all,
Okay,
they have done
then,
the
you
transaction.
pay the amount to him.
Yes.
They have to recover it from the private respondent.
Yes.
Lordship, on the last occasion, this honorable court directed the state respondent, the authority, to take a necessary step against the private respondent number 6, which was wrongly paid by the. Yes, Lordship, it is admitted that the competent authority has wrongly paid to the respondent number 6. But however, Lordship, a step has been taken against the respondent number 6 to recover the said amount, Lordship. So in that view of the matter, Lordship, since on the last occasion, this honorable court has even directed me to pay the cost of rupees 2,000, which I have paid before the High Court.
No, but we are basically not concerned with the payment of cost.
Yes,
We are concerned with the
Yes.
payment of the compensation amount.
yes.
You pay, and thereafter you recover it from the private
Yes.
respondent.
So Lordship, if we go by the instruction that we received from the competent authority, Lordship, there was amount on 7th of November, Lordship, which is at page 2, Lordship. Both the petitioner as well as the private respondent were summoned by the authority, by the commissioner paid, Lordship. And thereafter, Lordship, a report was there is a report which is at page 3, Lordship. If I'm allowed to read, Lordship.
Not necessary.
Okay, Lordship. Then
So what
Lordship,
was the
come to
total
the
amount?
Lordship,
Your Lordship,
What was the total amount?
total amount was 11 lakhs.
18,605.
Yes, Your Lordship, yes. 11,48,605. Out of that, they have.
And how much amount the private respondent has returned now?
2,40,000.
Yes, 2,40,000.
Only.
Yes.
Then you pay the remaining amount?
Yes.
Also, in that view of the matter, Lordship, since even there is an undertaking which is at page 6, Lordship. signed
What
by-
undertaking?
Undertaking by the page 5, page 5. Last paragraph. It said that now I see so and so on this date, 9 November 2023, to hereby undertake declare to pay. Here the word is used, declare to pay, surrender the remaining amount of rupees so and so, failing which necessary legal action may be initiated
Yes.
against me as per relevant penal section of law. Lordship. So, Lordship, it is the private respondent number 6 who is to pay this remaining.
No, how you recover it from the private respondent, it is your business.
Yes.
Petitioner is not at all concerned.
Lordship.
You make payment,
So, Lordship, in that way of the matter,
you
Lordship,
recover it from the erring officials for whose fault the amount was released to the private respondent.
Yes.
Why he should suffer?
I'll leave it to Lordship.
No, otherwise, what course of action is available?
Wrongly.
You conduct an inquiry
Lordship.
and recover it from those persons
Yes.
who are responsible for disbursing the amount to wrong person.
Lordship, sometime may be given, Lordship, so that I will take up the full instruction.
No, what instruction? He is suffering
Yes.
for your fault.
Lordship, as directed by this honorable court, Lordship, they, both the petitioner redirecting to the statement, to the submission, that yes, both the petitioner as well as the private on 7th of this. So, Lordship, sometime will be given, Lordship. Since the undertaking was also signed by the private respondent stating that he will, he will recover
we
the
will
same
not grant
balance
you
of-
time. We will also direct you to conduct inquiry against those persons who have dispersed it wrongly to the private respondent.
That I'll leave here.
Yes.
Yes, Your Lordship. Direction may be given, appropriate direction may be given to recover it from the erring officials. But as so far as the petitioner is concerned, he should be paid the dues within a reasonable period of time. Your Lordship, by the state respondents. That is my humble submission.
Or else, Lordship, a short date may be given, Lordship. So that
Why?
I will-
Why
I
short
will
date?
take a proper instruction from the.
No, this way you will linger the matter to it. Maybe you will carry it to 24, 25 like that.
Just recently, the respondent has.
No, what is his opinion? He says that he has already spent the entire amount.
Yes.
He is a poor person. From where he
Yes.
will make payment?
But he has also appended his signature by stating that
No, no,
he
no.
will pay the same amount.
Thereafter, you will take a plea that no, we have initiated legal action against him. Ultimately, what will happen? Nothing. So we will take it up at 2 o'clock. In the meantime, you obtain instruction from the respondent. We'll take it up at 2 p.m.
For admission, item number 21.
May I please, Your Lordship?
Yes.
Your Lordship, I have instruction to appear for Mr. P. Suri for the petitioner. Your Lordship, if this matter can be listed on 4th December, as he have some personal difficulties to appear today.
Achha. On behalf of
P.
Mr.
Suri.
P. Suri. Ms. So-and-so, learned counsel for the learned counsel, appearing on behalf of Mr. P. Suri,
Yes, Your Lordship.
submits that she has instruction to appear before the court and press for listening the matter when
On 4th
on
December.
4th of December. There is accordingly allowed. None appears for the respondent number 1 and 2, though the name of some advocates is reflected in the cause list.
For orders, item number 24.
May it please your lordship.
Yes, why this matter is listed in order column?
Lordship, perhaps because the notice upon the respondent number 2 is yet to be complete.
Not completed.
Yes,
You have
lordship.
taken step?
Yes, my lord. The Union of India represented by the Joint Secretary Ministry of Women and Child Development, Shastri Bhavan, New Delhi, lordship.
Yes. Office note. Where is the office note?
The state also has certain instruction to file an affidavit, lordship.
Heard Mr. J. Sekil, learned counsel for the petitioner, and also heard Miss. Yes, madam.
Lordship, I'm appearing on behalf of respondent number 3, 4, 5, and 6.
Learned Miss so-and-so, learned counsel for the respondent number 3, 4, 5, and 6.
Lordship.
3, 4, 5, and 6. Office note. Dated 31/10/2023 indicates that. No. Dated 6/9/2023 indicates that service report in respect of respondent number 2 is still awaited. You want to take fresh step?
Lordship,
Or
we
you
have
will
sent
await
through
service
registered post,
You will await service report.
my lord.
So list the matter after vacation.
Lordship, there is some urgency in this matter, so.
Urgency.
Lordship.
So when
So if the matter can be listed on 5th of December, Lordship.
whether service report will be receiving in the in
Lordship,
respect
the
of
necessary parties are 3, 4, and 5, and 6, Lordship.
not 2.
Lordship, which we have already filed our preliminary objection also, Lordship.
Okay.
Lordship.
Okay. List the matter on 4th of,
Fifth, Lordship.
5th of December. Everything service report upon respondent number
2,
2,
Lordship.
respondent number 2.
My lord.
Obliged, Lordship.
Bless you, Lordship.
For orders, item numbers 25 and 34.
May it please your Lordship.
Yes.
The item number 25 is WBC number 234 of 2023.
Yes.
Lordship, here, the brief facts of the case, Lordship, that on 6th of September 2022, the petitioner entered into a lease deed agreement with the Department of Tourism, the government of Nagaland. Lordship, lease deed was for a period of 5 years. Now, my lord will kindly appreciate this. According to the terms and conditions, the clause of the agreement, any party willing to discontinue with the lease deed agreement has to communicate to the other party 2 months prior to the cancellation of the lease deed. Without any valid ground, my lord will kindly appreciate that at clause 23, without resorting to that, even before the cancellation of the lease deed, the state respondents have entered into an agreement with another private party, Lordship, and has even handed over the property, Lordship. Now, my lord, the agreement clause has been violated. And my lord is fully aware that for cancellation of contract, in any contract agreement, my lord is fully aware that there should be certain valid grounds for cancellation of the agreement. Lordship is aware that there are certain ways of terminating a contract, an agreement, which is for an issue of performance in accordance with the terms of the contract, agreement, breach of contract, delay in fulfilling an obligation, repudiation, or frustration, Lordship. No ground. Plainly, the parties' contractual agreement has been violated by entering into an agreement with another party without issuing notice, Lordship, to the present petitioner. So, Lordship, in WBC number 234, the handing over of the tourist lodge to the private respondent number 4 by letter dated 6/10/2023 has been assailed. 6/10/2023, Lordship. Then subsequently, why the necessity for filing the WBC number 266 of 2023 has become necessitated is because my lord will appreciate that after approaching this honorable court, the state respondent hastily resorted into an action of issuing notice to vacate to the petitioner white letter dated 15/10/2023, which is assailed in the WBC number 266 for the fresh course of action, Lordship. Now, prima facie on the face of the record, my lord will kindly appreciate that there is a violation of the contractual agreement between the petitioner and the state respondents. And this honorable court, on the previous occasion, the matter was handled by my learned friend. Lordship, this honorable court is yet to grant interim protection by the notice dated 15/10/2023, which is assailed in WBC number 266, Lordship. Only 1 month's time is given to the petitioner, which is expiring 2 months' time, Lordship, my apologies, 2 months' time, which is expiring by 15th of this month, Lordship. So an interim protection, prima facie on the face of the record that the agreement between the petitioner and the state respondents have been violated by the department. Clearly, there is malafide, Lordship. And my lord will also kindly appreciate that it amounts to colorable exercise of power, Lordship. May I take a lordship to the annexures?
But Mr. Seki, the problem is that this case is listed in the order column today.
Yes, lordship, but an interim protection, lordship. Whether it is in the order or not, my lord is fully aware. There, I have no right to dictate this on the court. But any interim protection is required, lordship. If not, within a year, it is for a period of 5 years. If I may take your lordship to the agreement. May I show your lordship the agreement? May I take your lordship to WPC number 234, the item number 25.
Yes, so who is for the state respondent? Yes. What is your submission in respect of the interim protection? But the problem is the case is listed today in the order column. But
My lord, however,
that is,
without interim protection, the petition is going to become infractious. That is the urgency which I beg your lordship to kindly consider, lordship. Lordship is aware that for layman to approach the
when
honorable court, that's the last resort.
when the term of this 2 months will expire,
Lordship, on 15th
15th of this month.
of this month. The December 15, lordship.
Yeah, there is time. We will list it on next week, on any day, for consideration of your claim.
Monday.
Monday.
Monday, if my learned brother is okay.
Tuesday.
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 My lord. But lordship, may I kindly specifically make a mention in the order that the WBC number 234 of 2023 and 266 of 2023, it has to be clubbed together, lordship. Yesterday also my learned colleague made a mention, but today only 234K of 2023 was listed. These are analogous matters, connected issue. It has to be listed together. That is my humble request, your lordship.
No, whether here the appearance is completed in
Lord.
this 234.
234, in 234, the challenge made is the handing over of the tourist lodge to the private respondent,
That's
lordship.
all right, but whether all the respondents entered appearance.
It's only
There
the
is no
state
private
respondent's
respondent.
lordship.
No, or
The
there is
private
not.
respondent is yet to enter appearance, lordship.
4.
Yes, the private respondent number 4.
Have you taken any step?
Yes, lordship.
So, at the first instance, you have not been granted any interim stay. Now, would it be proper without appearance of the respondent number 4 if we consider the interim period?
Lordship, prima facie on the face of the report. Before the cancellation, the termination of the present contract, the tourist lodge, Dimapur, that the same building is already handed over to another party in violation of the agreement, which is still persisting, lordship, which is still
Already
alive.
handed over.
By the order, physically not handed over, but according to the order, according to the letter of handing over is already given to the private respondent, lordship, in violation of the existing agreement, which is still alive. And in the subsequent writ petition 266 of 2023, lordship, after all the illegal actions, learning that the petitioner has approached his honorable court, they have issued a letter for vacating the tourist lodge complex to the petitioner when he has already made a substantial investment, and within a period of 1 year, when the contract agreement, the lease deed is for 5 years, lordship. And without any ground, not even a single ground is mentioned on which clause the petitioner has violated the existing agreement of 5 years. Just plainly vacate the building. So, lordship, clearly there is a malafide intention, ulterior motive is there.
Okay, we will order to club together this.
My lord, your lordship.
And we will direct the ST to list the matter on Monday. Tuesday. Tuesday. I heard Mr. Jay Seki, Lord Head Counsel for the petitioner, and also heard Mr. Government advocate for the state respondent. Mr. Seki, Learned Counsel for the petitioner submits that WBC number 234/2023 and WBC number 266 of 2023 are analogous matter, and as such, a direction may be issued to the registry to list or to club together both the petition. Where Mr. Seki being not objected by Learned Counsel for the state respondent stands allowed, the ST shall list the matter on Tuesday by clubbing together writ petition number 234 with 266 of 2023.
Oblige, your lordship. Your Lordship, my Lord, if the information that we have received is correct, it appears my Lord is about to leave
Now,
today,
no,
Lordship. If not, we have item number 30, which may take at least 2 days to finish the argument.
2 days.
About 2 days, my Lord. Item number 30, my
No,
Lord.
no, my tenure is till today.
Oh, then in
It is
that
not
case, Lordship,
extended.
can we fix it on Tuesday? Item number 30.
No problem.
Tuesday. My Lord. Item number 30 on Tuesday, if my Lord may kindly allow.
Okay, as agreed by learned advocates of both the parties, list the matter on Tuesday.
My Lord. Oblige you, Lordship.
And 31, item number 31.
Oh, that we are not aware, Lordship.
31, this is a very small matter. Only
That's it.
10 minutes matter, Lordship. Time is still there. It's a gift.
No, it is already 1 o'clock. Already.
Only for 10 minutes we can finish up because it's a very small.
Acha. Okay. Okay. Okay.
For hearing item number 31.
May I please, Your Lordship?
Yes.
Your Lordship, earlier on 6 June 2022, the petitioner filed with petition number 99 of 2022, praying for granting minimum scale of pay. Your Lordship, and accordingly, this honorable court by order dated 9th June 2022, Your Lordship, which is in annexure 5, page 22. Your Lordship, it was disposed of, directing the state respondents to consider within 2 months.
To grant scale of pay.
Yes, my lord. Yes, my
Yes.
lord. Your Lordship, and accordingly, notice was served to the respondents. Your Lordship, however,
No,
without.
no, in this writ petition, no, in the writ petition number 99, direction was issued to grant scale of pay.
Yes, my
To
lord.
the petitioner.
Yes, my lord.
Whether that was carried out or not, that direction was carried out by the.
No, no, my
respondent.
lord. Yeah, my lord. However, without considering, we have received impugned office letter dated 30th June 2022, Your Lordship, which is in annexure 9.
Yes.
Your Lordship, here Your Lordship, here the letter was written by the additional secretary to the government of Nagaland to the secretary, Youth Resources and Sports Department, Nagaland. Your Lordship, the relevant portion is in para 2.
Of the petition.
No, my lord. In annexure 9, page 29. Annexure 9, page 29.
Yes.
Your Lordship, in para 2. Your Lordship, may I be allowed to read, Your Lordship?
Yes.
It may be noted that the state government has not adopted any scheme for grant of scale pay to fix pay work charge employees, nor is there any provision under revision of pay rules to grant scale pay to fix pay work charge employees. Your Lordship, and in annexure number 10, which is on page number 30.
Oh, what was the direction in 99?
Your Lordship,
to consider your pair or to grant you the scale of pay?
yes, my lord, to grant minimum scale of pay.
Then why, what happened?
Your Lordship, I make it very clear in my affidavit in opposition, Your Lordship. There is no policy of the state for granting of
Maybe,
pay.
but
to the-
in absence of any policy, can you disregard the order of the court?
Lordship. In absence of any policy of the state, how can we grant the petitioner?
In that case, you can file a review petition before the court or an appeal.
My lord, earlier writ appeal was filed by the state respondents.
Appeal was
Yes,
filed
another writ appeal
In,
in another case.
in another case.
Yes, my lord.
What happened in that case?
Your lordship, it was dismissed.
Dismissed.
Yes, my lord. Your lordship, it's a covered case. Your lordship, in the case of state of Punjab and other versus Jagjit Singh and others. Your lordship, the relevant portion is in page number 11 of my writ petition, para 12.
No, is the pair of this pair in this petition and the pair in 99 are same?
Yes, my lord. Yes, my lord.
Same.
Yes, my lord.
So on the same subject matter to writ petition.
Yes, my lord. We have received impugned letter.
Thereafter, this subsequent letter. Which one? 13/7. 13/7/2022.
Yes, my lord. 13 as well as 30th June 2022.
What is the order in 99?
Your lordship, it's in annexure 5, page 22. Annexure 5, page 22. Your lordship, the relevant portion is in page number 24. Page 24, the last paragraph. Since the representation was submitted only on 19/4/2022, this writ petition is disposed of with the direction that respondents should consider and dispose the same within a period of 3 months from the date of receipt of a copy of this order.
That's why I am asking you whether there was any direction to grant scale of pay or to consider and dispose of your petition. So here only to consider and dispose of your petition. Now they have disposed of your petition by stating that there is no scheme.
Yes, ma'am. Your lordship, since we have been challenging this letter, we're challenging this letter, these two letters. The question set aside these two letters and to consider the case of the petitioner. As
So
per
if there is
this-
no scheme, then how the court can issue direction?
Your lordship, it's a covered case. It's a covered case.
Covered case?
Yes, my lord. In Jagjit Singh, state of Punjab versus state of Punjab and others versus Jagjit Singh and others. Your lordship, it's a covered case. Your lordship, several fixed employees approached this honorable court, and this honorable court has disposed, directing the states to consider, and accordingly it was considered. Your lordship, I've annexed one writ petition. Your lordship, it's in annexure 11, page 31. Your lordship, here the petitioner was granted scale of pay, and accordingly by office order dated, your lordship, the petitioner was granted scale of pay, your lordship, in this order, in this office order. Your lordship, and
in view of the direction issued in this petition,
in connection to this writ petition number 167 K of 2018. Page 11, page 31, annexure 11.
and where is the order?
Your lordship, it's in the last page, page number 34. Your lordship, page 34. The type copy is in page number 34. Your lordship, I may be allowed to read, your lordship.
Not necessary. Yes, Mr. Imsen. So in this petition also 167 2018, there was a direction to consider and dispose of the writ petition.
Lordship,
And
that was-
pursuant to that order,
Yes.
So this office order was issued granting scale of pay to the petitioner.
I know that, Your Lordship.
Yes.
That was long time back.
No,
Now,
not long time. It was in 2020.
yes. Now, state has even filed an SLP,
Uh,
special petition for the Honorable Apex Court on this issue for the grant of skill up pay. It's not the only petition. We have many petitions for grant of pay, for grant of skill up pay to the fixed employees. Either may be called by the name of contingency, contract, ad hoc, or whatnot. So we have even filed a special petition before the Honorable Apex Court. So we cannot say that this is a covered case. Lordship, let this matter be given as a bartered matter and come up updatification.
Your Lordship, it's a covered case, Your Lordship.
Come up
May I know the
updatification.
case before Your Lordship?
Because,
No,
Your Lordship, because the petitioner is a contingency employee. If it is granted to the petitioner by this honorable court, order of this honorable court, then it will open a floodgate for coming all this contingency employees of the department taking the ratio. That is a problem, Your Lordship. So let us give it as a bartered matter and come up updatification, and we'll try to find out, see what could be done. Otherwise, if an order has been passed by this honorable court to there, allowing the petition, it will open a floodgate. Because we have thousands and thousands of contingency employees in the state.
So what
there
is
is
the
a
difference
problem.
between a contingency and
And
officer's employee?
petitioners are relying on some of the orders of the High Court, this honorable High Court. But order was, whether the order was given only to consider. So whether the department has considered that is the order he has submitted, whether the department has, government has considered that or not, we don't know. Because scale up is a big question for the department.
No. The case of
For the government,
Jagmeet
Your
Singh,
Lordship.
the Supreme Court has made it clear that at least they are entitled to minimum scale of pay.
Yes, Your Lordship.
That is
So
there.
how can you ignore the judgment of Supreme Court?
That is why, Your Lordship, I'm saying, yes, Jagmeet Singh case is there, same work, same things, but still then, Your Lordship, we have filed an appeal, SLB before the Honorable Apex Court, in the same matter for the grant of scale up pay. So till that is disposed of by the Honorable Apex Court, it has to
When
be
that
stayed.
matter is listed,
Lordship, I have the Lordship, the registered number of special petition filed before the Supreme Court on the issue of minimum scale up pay are, the Lordship will find 35341, 35341, stroke again 35342, stroke 35345, stroke 35348, and 35353 of 2023, Your Lordship. Because this
no,
is
when the matter is fixed,
Lordship, whether it is state or not, but it is, I think, it is likely to be pronounced by the apex court very soon, very soon.
You tell me the date when it is fixed.
We filed in 2023 this year itself, especially petition
This
against
year.
the judgment order passed by the.
No, is it the number or it is diary number?
Yeah, these are the numbers. These are the numbers. These are the numbers. That's why this SLB, which has been filed by the state before the Honorable Apex Court, has been disposed of. This, I think it's better that in the interest of justice, this present case is had.
Your Lordship,
Okay,
several,
since when you are serving?
Your Lordship, from 1st December 2011.
2011.
Yes, my lord.
So you have some years.
12 years, my lord.
Okay, wait for some time then. Let the Supreme Court dispose of this SLP.
Your Lordship, on earlier occasion, the state respondent has stated that to this honorable court. Your Lordship, however, this honorable court has clearly stated that the facts and appointments are different.
Lordship, let this winter be kept as bartered income of after the winter vacation.
No, maybe I cannot keep it part hard. That's because there is no certainty
That
that
is
I
my
will
prayer.
come back here.
That is my prayer. Then, Lordship, let us fix it after vacation.
No, my lord, I humbly pray this with
Keep
petition
my
will be
friend
disposed of.
equipped.
Pardon?
Your Lordship, I humbly pray this with petition will be disposed of. Your Lordship, it's
No, that's all right. Even I pass the order, they may not implement it on the ground that these SLPs are pending before the Supreme Court. It will serve no purpose.
Your Lordship, the Your Lordship, same
In
yardstick should
disposing
be.
of, I have no problem. But the problem is whether your problem will be solved or not. That is the question.
Yes, ma'am. Your Lordship, several fixed employees were granted scale of pay, which came before this honorable court.
We have granted it. We have passed the order, and they have also granted it. Now
Yes,
they
ma'am.
have taken it differently.
Lordship, as a senior counsel for the state, Lordship, this kind of scale up pay is a matter which is confronting this court in all the times. That is why, if a certain order is passed by this honorable court, it will open a floodgate. Litigation will come again, taking
No,
the
that's
issue. That's why, Lordship, my
we
prayer is
are-
that
No,
since the
no.
matter is in the apex court, Lordship, and it may likely to be disposed of early, let this matter will come up after the vacation, so that.
Wait till vacation is over.
Your Lordship, it's a fixed matter, so I humbly pray that.
Pardon?
Your Lordship, since it has been postponing for many times, so
That's all right, but
Your Lordship,
they may not implement the direction of this court, no? So wait till disposal of this SLP. Till vacation is over. Pardon, miss, your good name, please.
Decreasing.
Learned counsel for the petitioner and also our Mr. M. Imson, learned senior government advocate for the state respondent. Mr. Imson, learned senior government advocate, submits that in respect of the same subject matter, the state has preferred SLP number 3534 3534. Is it correct?
Correct. Lordship.
3534.
Correct. 35341.
35341, 35342, 35345, 35348, 35353 of 2023. And the matter will be disposed of very soon. And on such count, Mr. Imsen prays for listing the matter after vacation. Accordingly, it is provided that Resti shall list this matter after vacation. Or should we fix a date?
After vacation.
After vacation, we will fix a date. Yes, suggested date 24. 16? January. 16th of January.
Motion. Published motion.
You will take mine and then. One.
After a week.
For admission, item number 16.
Where is council for the petitioner?
May I please, your Lordship?
Ah.
Lordship, just now I had an interaction with SDO Civil Bank, and then I have been informed that they want a week's time, Lordship.
Which time?
Week's time, Lordship.
They will be able to recover the amount? Or what arrangement they will do? They will make?
Lordship, most probably they will go for inquiry and then do the full, Lordship. So they are taking keen concern in this issue, Lordship.
No, keen concern will not do.
Lordship. So a week's time, so that let them come in the form of instruction in a written instruction, Lordship. So a week's time may be given. Since most of the incumbent, now the present officer there, most of the incumbent has been transferred out, and then the new officer is in place, Lordship. So most of them are not aware, but however, they are taking a serious.
So you first make payment. Make payment.
Pardon, Lordship.
You first make payment to the petitioner, and they have to recover the amount from the respondent.
Lordship, so a week's time may be given, Lordship, so that we will do the needful, Lordship. The last occasion, this honorable court has directed me to pay rupees 2,000.
No, that is a different matter.
That I have made a payment, and then I would like to place that on the court.
No, not necessary. It is already on the record.
No.
May I please, your lordship,
Ah.
if few times may be granted to us, my senior is yet to reach the courtroom. So
Where is he?
we need his instruction. He's on the way, sis.
Lordship may please to grant a week stand.
It will ultimately boil down to a responsibility only, your lordship. So even if it is disposed of, my humble submission is the petitioner has been suffering for quite some time now.
Heard Mr. T. Congener, learned counsel for the petitioner, and also heard Mr. V. Zimomi, learned government advocate for the state respondent. Pursuant to order dated 31/10/2023, Mr. V. Zimomi, learned government advocate, has obtained instruction from the respondent authorities and placed the same before this court. And also pays for granting him some more time, no, a week time, week time to obtain further instruction. Whereas Mr. Congener, learned counsel for the petitioner, has vehemently opposed the petition, opposed the pair, and contended to dispose of the petition by issuing direction to the respondent authorities to make payment of the amount to the petitioner. Having heard the submission of learned counsel for both the parties, it is provided that recusal is the matter on 5th of December, so as to enable Mr. Zimomi, and learned state counsel for obtaining fresh instruction in respect of making payment of the amount to the petitioner. In the event of failing to make payment of the amount, the court will consider issuing direction to the appropriate authority to conduct inquiry against the erring officials for whose fault the amount was disbursed to the private respondent number 5. Private respondent number 6. Accordingly, Justice shall list the matter 5th of December.